who are in charge of defense and also the ministers of foreign trade. In most of the East Asian countries, foreign minister also minister for the trade, international trade. But several other countries, it is not the case. As someone mentioned that after WTO, the trade minister face is more seen at international fora than the foreign minister, or maybe both of them are equal. The another potential candidate could be the national security advisor. National security, those who deal with the national security. And another question as to the, I have seen that the persons like diplomats, consular officers, and those who represent representatives to the international organizations, accredited to international organizations, special missions, etc., they would not be covered because they otherwise enjoy. There I have a question, but when it gone to the drafting committee, I have seen the drafting committee chairman's report. They have collapsed the entire list of those who would not be covered. Surprisingly, they mentioned about the military personnel. I read that the concise draft. The present draft articles are without prejudice to the immunity from criminal jurisdiction enjoyed under international law by persons connected with the diplomatic missions, consular posts, special missions, international organizations, and military forces of a state. I don't know. It seems it has come up at the drafting stage. I'm wondering, but whereas when they consider persons under international cooperation agreements, economic and commercial cooperation agreements, if persons are sent, a state sends officers to another state, the commission also said, commission members, drafting committee commission members said, these persons would not enjoy any immunity because they belong to some special category. If that is the case, so far as military personnel are concerned, military forces, without any agreement or without consent of the receiving state or a territorial state, a military person during peacetime, he cannot enter. The case dealt with by the International Court of Justice in the Germany, Italy, it's about the during wartime. The activities, atrocities committed by German forces during Second World War, they enjoy immunity, they cannot be questioned. That is understandable. But if somebody comes into my country with uniform, without my consent, whether express consent or implicit consent, he is like anybody. He cannot enjoy immunity. But by putting here, as paragraph 2 of Article 1, this including military forces, I think it's going to be very dangerous. Another thing, so far as the American practice is concerned, the kind of immunity, they have several agreements with African countries. The level of immunity they enjoy is equal to or maybe less than the administrative, technical and administrative staff in the mission. Plus, of course, about the carrying guns and weapons, etc., between the camps, between the action place to the camp or barracks, that's a different story. So we have a serious doubts about this, adding this thing at the drafting stage, military forces of a state at the end. The third question, the immunity, exceptions to immunity. Yes, this is going to be another major issue. Of course, we look forward to the reports of the special report here, and we will, for the time being, we reserve our comments. But I would cite the ICJ decision in the German versus the Italy, where immunity is a preliminary issue. Immunity is a procedural issue. Once any judicial body decides, yes, it has a jurisdiction, but these individuals, this situation cannot be considered by me because they enjoy immunity. That means you don't have jurisdiction. Once you decide that there is no jurisdiction, how could, again, some kind of that shield cannot be, even ICJ said, even war governments or some higher norm cannot be used to pierce the shield of immunity. So with this I end, and I would like to hear your views. Thank you, sir.
Thank you very much for your questions. So Michael Wood, would you like to answer some of these?
Some of these. Thank you very much indeed. You've obviously read what the Commission has been doing very, very closely. On customary international law first, my own view is that the change of title from formation and evidence of customary international law to identification of customary international law does not change the scope of the topic. The draft conclusion that I put forward was not sent to the drafting committee, and I will revise it to reflect the new title. But that doesn't affect the scope. As we explain in our report this year, we say that that change of title does not mean that we're not going to be dealing with the formation and evidence of customary international law. I think one of the reasons that led colleagues on the Commission to prefer the simpler title was they didn't like the emphasis on formation. They said what you're really doing is telling lawyers and judges how they can identify whether or not something is a rule of customary international law. Now, in order to do that, of course, you have to understand whether it's been formed, whether there has been enough state practice, enough opinio juris, etc. But nevertheless, the emphasis on the dynamic element of formation as opposed to the picking out in a point of time whether something is the rule was thought to be, it was thought preferable to avoid that. That was the reason for the change of title. Now, you raised correctly the important point that it is not the purpose of this topic to say what the rules of customary international law are in substance. Obviously, we're not going to set out what rules are on state immunity or on any other topic as part of the customary international law topic. It's important to be clear that what we're concerned with are the secondary or systemic rules, that is, what are the rules or principles for identifying whether a rule of customary international law exists or not. It's not to look at the substance. So colleagues who said, oh, you must, well, I won't go into it, but the point's, I think, a simple one, but a very fundamental one, and it's quite difficult to express. The purpose is not to decide what is customary international law. The purpose is to decide how you decide what is customary international law. Now, you rightly stress the importance of clarifying the relationship between customary law and general principles of law. I get very confused when I see references to general international law. When people, the International Court and others, refer to general international law, what are they talking about? Are they talking about customary international law? Are they talking about general principles of international law? Are they talking about widely accepted treaties? Are they talking about all of these things? I think they need to be clear. Now, often in domestic cases especially, but I think also at the International Court, it's not clear whether the court is talking about a rule of custom or a rule of, or a general principle of law. They leave that deliberately unclear. And that's sometimes necessary in domestic cases, which you have to approach with great caution, I think. It depends on the Constitution, and the Constitution may refer to general principles of international law, some very strange concept that you don't find in Article 38 of the statute. So there's a lot of clarification, I think, which, without being dogmatic and rigid, would be helpful. And if it encourages states and judges and lawyers generally to use terminology carefully in this area. I think that will help to clarify international law. Now, coming on to your points about immunity, you said one possible addition to the Troika could be the National Security Advisor. Well, I think it depends very much what you mean by the National Security Advisor. If you look at the National Security Advisor in the US system, for example, who seems to be a figure as powerful, if not more powerful, than the Secretary of State sometimes, maybe that kind of a National Security Advisor should be within the Troika, but it's not really the title, it's more the role that's being played. The case I referred to, it was the head of the Office for National Security, who was really a mid-level official in the country concerned. And there the court had little difficulty in finding they were not within this small circle of officials entitled to high level, to immunity ratione personae. You raise interesting points about the exclusion clause in paragraph 2 of Article 1 of the draft articles, and said you had concerns, for example, about the reference to, or particularly the reference to military forces. I mean, I entirely agree with you that one has to be clear about this, but the article merely is a saving clause for those rules of, special rules of international law that govern the immunity of persons connected with diplomatic missions or military forces. And in the case of military forces, there are many important rules of international law in status of forces agreements, possibly in customary international law if you invite, I agree the invitation is important, a foreign military unit to visit. I don't think the article can be read as extending in any way the rules of international law in this field. It merely is a saving clause to say that nothing we're doing in this topic affects existing special regimes, if you like, which include, importantly, I think, the regime relating to military forces. Exceptions, well, we'll just have to wait and see what is proposed. I do agree with you that the International Court of Justice has given some very important indications in the Germany-Italy case. Of course, that was a case dealing with immunity in civil proceedings rather than from criminal, the immunity of the state in civil proceedings rather than the immunity of individual officials in criminal proceedings. So the analogy is perhaps not exact, but I think the approach of the International Court, which was to say essentially no exceptions from state immunity at least in this field, is one that we'll have to look at very carefully and probably be guided by. Thank you.
Thank you very much. I think Sir Michael Wood has addressed most of the questions, but India is asking for the floor again. You have the floor, sir.
I'm not addressing, I'm not posing any questions. I just want to read, because my issue is about the immunities. Troika plus Ministers of Defense, Ministers of International Trade, and possibly the National Security Advisors. That's my question, because there was a case in South Africa where Israeli security people, when somebody filed a criminal case against them because they are party to IC International Court, Criminal Court. Pursuant to that, they enacted a law criminalizing some of the acts which are mentioned. They sought to prosecute. Somehow it did not occur. That was behind my mind. But so far as Troika plus Ministers of Defense and Ministers of Foreign Trade and possibly other candidates. In this context, I want to mention, because I have heard, maybe we should hear the member states so far as whether Troika, it should be confined to Troika and plus. And if you go by criteria, maybe perhaps criteria laid down by International Law Commission, as mentioned by Mr. Naren Singh also, we need to go. In this context, I want to read the Secretary General also mentioned in his opening remarks, and also he referred to his statement. I read his statement, the statement made by Secretary General at the ILC. ALCO is of the view that without a strong